I've made a new friend this year. What I like best about Steve Anderson is his inability to say no to any opportunity to support the Equal Rights Amendment. Anderson is spelled with two S's, standing for super supporter. He has been a practicing lawyer since 1992 and is licensed to practice in Illinois, the Seventh Circuit, and the United States Supreme Court. Steve is a commissioner of human rights for the state of Illinois and is a retired member of the Illinois House of Representatives. He was floor leader for the House Republican caucus and oversaw all debate on the House floor. During his last session in the Illinois House, Representative Anderson was the chief Republican sponsor of the Equal Rights Amendment and successfully passed the amendment, making Illinois the 37th state to pass the ERA. He's also published on the topic of passage of the ERA in the NYU Review of Law and Social Change, and has written numerous opinion editorials on the subject. In January 2020, he was featured in an article published in the Washington Post called "The Man Celebrating Virginia's Historic Equal Rights Amendment Vote" by Petula Dvorak. Most recently, he was singled out during floor debate on the removal of the federal deadline for the ERA by Speaker Nancy Pelosi for his bipartisan efforts to pass the ERA. Recently, and this is very exciting, Steve became a board member of the Equal Rights Coalition, our national organization. Since passage of the ERA in Illinois, Representative Anderson has traveled the country advocating for ratification in additional states. He's been to Virginia, Arizona, Florida, Missouri, New York, Utah, Washington, D.C. And when we initially invited him to be our guest speaker for the annual meeting, we had planned to host Steve and his wife in North Carolina for a full week at a very expensive, luxurious hotel. Because of COVID-19, we ended up with a virtual Steve today, and he got a nice Dads for ERA t-shirt in the mail. Welcome, Representative Steve Anderson.
Thank you. Good morning, everyone. How are you? I understand it's a beautiful day in North Carolina. You can see out, if you can see out my window, it's a little cloudy here in Illinois, but that's okay. It doesn't affect my enthusiasm, my excitement for having the opportunity to play a supporting role in this fight, your fight, to make the Equal Rights Amendment, the 28th Amendment to the U.S. Constitution. So, you know, normally I start when I speak about the Equal Rights Amendment, I tell a little story about how old I was when this actually got started. But today, I think I'd like to change that just a little bit and suggest to you that there is one word that motivates me to continue this fight. And that one word, oddly enough, is laundry. It's laundry. And it's not my laundry. It's not anybody else's laundry that I know, but it happened 2 days ago. 2 days ago, a woman jurist from the Seventh Circuit, from my circuit, whether you agree with her politics or not, was forced by a senator from the great state of Louisiana, a guy named Joseph Kennedy, no relation to those Kennedys, asked her what he called a sincere question. And that sincere question was, who does the laundry in your house? And he did it sitting back. I don't know if you can see how, sitting back, tapping his table, and then asked this ridiculous question. And I'll tell you what, the jurist, Judge Barrett, laughed. You know, she chuckled because she had to. And then she answered the question, you know, in an appropriate way. Can you imagine such a thing? Can you imagine a man being asked that? Not a chance. Not a chance that that sort of a question would be asked. And it's not just that it's an embarrassing question. It's an example of power, of misogynistic power. That wasn't an accident that he was sitting back casual, that he tapped his desk, that he asked a sincere but stupid question. It was a way to remind her and every other woman listening who was in charge. He was exercising his power and his privilege over women. That's what that question was. It wasn't just a stupid question. It was an example of male power and controlling other people. That sort of thing offends me like nobody's business. That's what charges me up. That's what gets me up in the morning and says, we need to pass this. We need to finish this. And so it's not why I'm here today. I'm here today to be inspirational, I hope, but I am angry when things like that happen. I'm very angry because it's not cute. It's much more than that. It's much deeper than that. So when we talk, though, about the ERA, I am often asked, why do you do it? You know, why you, Steve Andersson? Why do you care so much about this? Do you have a daughter? The answer, by the way, is yes. Do you have a wife? The answer is yes. Do you have a mother? Obviously, the answer would have been yes. She's passed away. But that's not why I do it. I mean, yes, to all those things, I do it for them. But that is not why I do it. Why I do it is for a broader reason. If you picture with me a boardroom, right? 9 or 12 seats at the board table of any business, any government, you name it. And you picture that 9 or 12 people in that room are all people who look exactly like me, old white men. Think about the range or the universe of ideas that come out of that room. Well, we probably all have similar backgrounds, probably have similar educations, probably have similar life experiences, which means guess what? The ideas in that room are probably gonna be similar. Now, what if you change that room? What if now it is full of both some men, such as myself, or not, quite honestly, but it's full of women. It's full of members of the LGBTQ community. It's full of Asian Americans, African Americans, all the varieties of mankind that we have. Now suddenly those backgrounds, those educations, those ideas, that universe of ideas, instead of being like this, blows up to this. The solutions that we can come up with, political, philosophical, technological, all of that goes through the roof when we expand who's in the room. That's why I do this. I do it because it helps everyone. It helps all of us when we're there. There are even scientific studies that back up what I just said, that the invention cycle, even in technology, goes up when people from across the globe or across different experiences are in that room. So this is not just a theory or my fond belief. This is fact. And we're woefully short on facts these days. I think we may all agree in the political dialogue. So that's what I fight for. That's what this is all about. Now, you are an advocacy group, and I love that. I'm so glad that you're there in North Carolina fighting for this. So we have to talk, or I want to talk, about advocacy, about what we're doing and why we need to do it strategically, because you're going to get, I'm sure you've already gotten, a lot of objections. Why do we need this, for example, is the number one question. Well, let me tell you a couple of answers to that I believe. Number one is, it's the Constitution is the only thing that is mostly permanent. Of course, nothing is eternally permanent, but it is mostly permanent and largely unchangeable. It's difficult to change the Constitution. So when people tell you, well, you women, you already have rights. You really do. I mean, you have them at the state level. You know, we have a pay equity bill that protects women, or we have human rights laws that say you can't discriminate against women and others. Well, that's true, but you know, there was also a requirement in federal law through executive order in the military. And that question was, can transsexual people serve in the military? And it used to be yes. Used to be, and they tossed out the old don't ask, don't tell, so that the LGBTQ community can serve in the military. It used to be the answer. But the current president signed an executive order changing that. And that was it. That was done. And there's no remedy for that. So with a snap of a finger, a signature on a piece of paper, those rights were wiped away. Those rights were wiped away. And just as easily, that could happen with state laws and federal laws. And I think we're seeing that right now. I think we're seeing the rollback of women's rights and many other people's rights. And that is the danger we face unless there is an equal rights amendment to the Constitution. So this is not a theoretical battle. This is not that we don't need it, we've already gotten it. This is not the fact that, well, women have achieved so much. The Speaker of the House is a woman. Many of our state houses are filled with women senators and representatives. All true, but it can go away in a heartbeat, and we're seeing that right now. So if you're asked that question, why do we need it? That's the answer. The other question, or the other argument that is commonly used against us is, well, the 14th Amendment covers it. You know, why do you need it? Well, my immediate reason, my off-the-cuff, cheap answer to that is, really? If that were true, why did we have to have the 19th Amendment? Why, in God's name, if the 14th Amendment covers women's rights, did it not cover the right to vote, the most fundamental, perhaps, of rights? And it didn't. So that's an easy one to toss away. But if you even want to dig further, you can, we could, I'm a lawyer by trade, we could dig into the cases. And what it would show you is that the rights under the 14th Amendment for women are subject to a type of scrutiny called intermediate scrutiny. It's kind of like this, down here. There's a lower one for non-constitutional rights, but there's a higher one called strict scrutiny that is available for race-based claims. So women are deemed a lesser class under both the Constitution and the Supreme Court case law. It is a simple fact. So for those who say the 14th Amendment got you covered, no, it does not. It absolutely does not. And so another reason why we have to keep fighting for it. The other argument, and I love going through the arguments because they're so ludicrous, is this idea that the ERA is dead. It died in the 80s because there was a deadline attached to the bill that created the process for ratification. Well, I would challenge you. I would ask you to go and look up the bill, from 1971 or 72. It passed in 72, but it might be a 1971 bill. Go look at the bill and find me the deadline. You'll read the bill and you'll find there's 3 sections. One section is the 24 words of what the amendment says. The second section says it's delayed for a year for people to kind of get up to speed once passed. And the third section is nothing important. Did you hear me say anything about deadline? I didn't, because it's not in those sections. It's not in the bill. It's in a section of the bill, but it's not the bill itself. It's called the whereas clauses. These are the clauses where people who write bills stick laudatory language about their bill. Whereas my bill is the best bill since sliced bread. Whereas I really think that this bill will do all these wonderful things. Whereas there's a deadline. That's where they stuck it. And they didn't stick it there by accident. The drafters of the bill knew that the Republicans in 72 wanted a deadline. So they threw it in there. But you know what? Those sections are what we call non-operative. They don't count. The only sections that count are the section 1, 2, and 3. It's laudatory language. And they put it there on purpose because that satisfied some of the senators or representatives, but it doesn't have any bearing. And so when we're in litigation, which we'll talk about, when we're in litigation, that's one of the main arguments for why it doesn't have any bearing. There's another reason though, And this one is my favorite when we keep hearing about originalist judges, when we're talking about the Amy Coney Barrett confirmation process. In that process, they keep talking about how she's an originalist, and so many others on the conservative side are originalists. That means you don't read into the Constitution things that aren't there. Okay, I will take them at their word on that. So let's look at the Constitution as far as what it says about amending the Constitution. And it says there are two things that you need to amend the Constitution. One, a bill that passes through both houses of Congress or both chambers of Congress by a supermajority. That's done. Check. Number two, you need 3/5 of the states to ratify that constitutional amendment. In our time, that's 38 states. We've done that, 38 states. Now I'm looking for the thing that says, oh, but there's a timeline or a time limit. That's not in the Constitution. It doesn't exist. And so these originalists, if they're going to be true to their word, there is no deadline. There can't be, because it's not in the Constitution. There's only two requirements, and we've met them. So my argument is that the ERA is already a part of the US Constitution. It is the 28th Amendment right now. And so bearing that in mind, these are the arguments that we have to make, certainly in front of the Supreme Court, et cetera. But it's very, very real that the arguments that we're making right now could very well prevail, and we will win on those alone. But that's not all we're doing. We're also pushing, as Jimmy said in the beginning, we're also pushing to repeal the amendment that's in the whereas clause. Yes, we are. We're trying to repeal it. I was there in February, I believe it was, of this year before COVID. And I watched them successfully repeal it in the House. Of course, it's in the Senate right now, which is less favorable. But we did that. And that's based on, again, Supreme Court case law that says the Congress can undo what it does. In other words, it's in charge of its own body. So as easily as it can make a deadline, it can likewise remove the deadline. That's up to them. And that's their distinction. Their power, if you will. That's not the court's power. So we're going to do that as well, hopefully in the new year, so that we add just another argument to why the ERA has already passed. But like I told you, I said, you're an advocacy group and we're here talking about advocacy. So I've tried to give you some of the rebuttal arguments for why they're wrong, why the anti-ERA folks are wrong, and I hope that helps. But I also want to talk about the strategies we can use to try to advance it, not just rebut arguments, but advance it, make our arguments known. And the number one of these for me is what I like to call positive pressure. Positive pressure. And that means you cannot possibly succeed in Republican states with largely Republican held districts, either in Congress, in the Senate or the House, or at your local state level, if they're all Republicans and they already have an opinion about this, if you do one thing. You won't succeed if you do one thing, which is you send in a bunch of Democrats into their offices and yell at them and tell them we're going to vote you out of office, okay? If you can vote them out of office, great, then do it. But the reality probably is your districts are mapped similar to ours, which is they're drafted on a partisan basis. So you have hard Republican districts, which means it's very difficult to get them out of office. And more importantly, if they are hard Republican districts that you're dealing with, then your representatives from those districts are not worried about the general election, and they're not worried about Democratic votes. In fact, they don't expect to get Democratic votes. They're worried about the Republican primary. That's what they're worried about. And they should be, from a purely cavalier, I gotta win kind of situation. So if that's true, this is what positive pressure is. It means finding Republican women, well, Republican anybody, who supports the ERA, who can understand our arguments and can go into that office and say, look, Senator so-and-so, I'm a Republican and I support the ERA, and here's why. And you know what? If you vote with me on this important bill, I'm not going to forget, and I'm not going away. I'll be there for you. I'll be there for you when you need somebody walking in your parade. I'll be there for you knocking on doors. I'll be there for you writing a check, and I'll be voting for you during that primary. That, my friends, can change the dialogue. Because if you get enough of those people, it might be hard to find those people, but they're out there. I'm one of them. I hope I'm not the only one. But they're out there. I'm convinced of it. I see it. And if you do that, that's positive pressure, because now they have a chance of setting off those people who are otherwise going to primary them. That's reality. So now I'm asking something very hard of you. You have to find those people. You have to motivate them. You have to answer their questions. And so I'm just recognizing I'm asking you for something big, but it's the only way we're going to succeed. So please think about that. And then there's one major elephant, gorilla in the room that we haven't talked about that we do have to talk about in order to convince Republicans and others to be on our side. And that elephant in the room, that's not a political pun, but the elephant in the room is abortion. We have to talk about it. You can't shy away from it with your senators and representatives. You have to address the topic. And I'll tell you how I address the topic. It's a lie. The conflating, the combination of abortion and the ERA is a lie. But that's not enough. You can't just say that, even though that happens to be true. There are two cases. These cases come out of state courts where the states have mini ERAs, in other words, ERAs at the state level that are exactly the same as the proposed, or in my opinion, the ratified 28th Amendment. And in those two states, Connecticut and New Mexico, so very far apart, there are two cases, one in each state, that says public funding must be allowed for abortion based on the state level ERA. The anti-abortion people, and by the way, I am a pro-life Republican, so make no mistake, but those who are trying to use that to fight against the ERA will say, ha, there you are, there you have it, it's proof. The ERA and abortion are tied together. But if you dig just a little bit into the cases, you'll find out that too is a lie. What they did in those two states was they didn't say abortions are prohibited for women, which kind of would be okay anyway, because only women can have abortions. But they didn't say that. What they did was they changed a definition in their state codes. And that definition was not about abortion specifically. It was the definition of medical necessity. In other words, for insurance coverage, in order to get insurance coverage for a medical process, it has to be necessary, right? If I want to get a facelift, that's not medically necessary. I'm going to have to pay that without insurance. Normal, fine, appropriate. But they changed it and they said for men, I kid you not, for men, medical necessity means whatever the doctor says it means. If the doctor says it's necessary, it's necessary. For women, they said it's only those things that don't involve abortion. Only abortion. And if anything, the only abortion that would be allowed under their medical necessity statute was ectopic pregnancies. In other words, those that would threaten the life, the child couldn't possibly survive, but it could threaten the life of the woman. Well, I can tell you for certain that there are a great many other things in pregnancy that can kill both the child and the mother that are not ectopic pregnancies. But that's, that was their view of it. So when it got to those courts in those two states, the states did not invoke the mini ERAs in their own states to invalidate abortion funding. They invalidated a definition. They said the definition has to be the same. I try to pull it away the best I can from the idea of abortion when examining this question. And I'll say this, men have testes, women have uteruses, right? I think that's generally the process. I'm not a doctor, but I think that that's a fair statement. If that's the case and I get cancer and my wife gets cancer, the question isn't about medical necessity. The question isn't, do I have a uterus or testes? It's, do I have cancer? It's the cancer. It's not the place in the body that matters. And that's what these courts were trying to say. So these statements that the ERA must cover abortion are lies. They're misconstruing those cases. They're confusing people by creating that. So it's simply not true, and it has never been true. I also think if there are Republicans in the room, that this is hurting the pro-life cause. If you believe in the pro-life movement, this hurts the pro-life movement. Why? Because it's tying it to something false. And most people have a bit of a BS detector, right? You know, they can tell when they're being fed a line. And it really doesn't make any sense that something that can only affect the biological makeup of a woman and not a man could violate an equal protection clause. It just doesn't sound right. So what happens when you say things like that is people's BS detectors go off. And they say, well, if you're lying about this, maybe you're lying about the pro-life movement too. Maybe you're hurting that cause. So I think there's a very legitimate Republican pro-life argument for getting these two issues separated. And it would do a wonderful thing. It would allow Republicans, men and women alike, to say something fundamental. We believe in the rights of women. How hard can that be? Yeah. How wonderful could that be? That's Steve, what I'm looking for, and that's what we're talking about. So I could probably talk for hours, yes, but I shouldn't, because you have a meeting. And so I'm going to thank you at this point for letting me take some of your time. And I'm happy if there is time and interest to answer any questions that I can.
Steve, thank you so much. And I want some hand clapping from the reaction button down there. And we do have some time for questions. You answered a lot of them as I saw them pass, but I'm going to call on Ann Von Brock to throw out the questions. Ann?
Okay, thank you, Steve. This was very informative, and we do have a few questions. You have probably touched on some of it in your remarks, but I will share a few of them with you.
Sure.
The first one is, why, generally speaking, do only the Democrats in General Assemblies or state legislatures support the ERA?
Sure. There are a handful of Republican legislators who have supported the ERA. There was, I want to say, maybe 10 in the House for the repeal of the deadline who did support it. But 10 out of 418 or whatever the number is in Congress is not much. The answer, I think, to the question really does go back to abortion. Remember that this has been such an assumption on the part of people for 50 years now that the two are tied because of a woman from the great state of Illinois named Phyllis Schlafly who tied the two issues together. Yeah, I agree. Patricia Sledge just did this, and I agree. But the reality was she was a very effective advocate, unfortunately, for her very misguided cause. But what that means is that any Republican who says I'm pro-ERA is moved in the pro-life movement from being pro-life to pro-choice involuntarily. They're just labeled that way. And that's what generates a primary. And that's a big issue in Republican politics. As it is, I think, in all politics, but it's a major issue. So the reality is that's why they're afraid. They're afraid of their base. That's why I'm trying desperately to separate the issues, because once we separate the issues, then, and undo what Mrs. Schlafly, as she liked to be called, what Mrs. Schlafly did, if we can separate those two issues, then Republicans will get on board. I believe in droves.
Got it. Great. Thank you so much. Along those same lines, we've got a couple of questions around how do we approach Republican women to support the ERA? Where do we find those Republicans who could be on our side for the Equal Rights Amendment?
I think there's maybe a couple of strategies for that. One is you gotta ask. I mean, I know you have friends who are Republicans. I know you do, and any of them who are out there, start by asking if you can have a coffee, with a group of Republican women, and say, I'm not coming in to convert you to be Democrats, but I do want to talk to you about why the ERA is good for Republicans as well. You start with a group like that. Maybe you find a sympathetic legislator, a Republican legislator. I mean, I was one, and I had 11 out of 44 in my House caucus in Illinois. So I had 25% of my caucus was voting yes on the ERA. So that might be easier in a blue state like Illinois, but I believe it exists. But let's say you could find even one, have that person host a town hall, and then you guys come in and be the speakers. But make it a Republican town hall. Invite them, as specifically we want to talk about it from the Republican standpoint. Hell, if you found it, I'd be happy to Zoom in or drive in. As Jimmy said, I'll do anything, anywhere to advance this. And I have found, by the way, when I have spoken, when I've gone to Capitol Hill and spoken to the staffers for the Senate and for the House, and I've gone with my ERA coalition staff, when they listen to me, I'm told afterwards by my staff, boy, they really pay attention when you talk. And it's not because I'm such a charming, or delightful speaker. It's because I'm a Republican. Because I start with that. I say, I'm a pro-life Republican for the ERA. Now they're listening. So if you can find the same sort of thing, or if you want me to come, I'll come. But it's better if it's a North Carolinian than some fellow from Illinois. That would be huge. So those are a couple of suggestions.
Great, thank you so much. If we've got time, I've got two more quick questions. One is, does the Equal Rights Amendment cover the LGBTQIA plus individuals? How do you see that?
We don't know yet because there's been no case law on it, but my guess would be it does. And the reason that I would guess that is recently Title IX, of the Civil Rights Act relating to gender-based discrimination in sports and education was very recently held to apply to the LGBTQ community as well. In other words, they read the term there. I think it was even the term gender in those cases, but it might have been sex. Either way, they read it broadly, and that was the current Supreme Court. So that was pretty interesting. But if you look at that as a precursor to what would happen with the ERA, it would suggest that it would cover the LGBTQ community, which I fully support.
That's great. Thank you so much. I think we're out of time, so I'll stop peppering you with questions now and turn it back over to Jimmy. Thank you so much.
Steve, thank you a million. We were planning a really fancy cocktail with Republicans while you were going to be with us as well. But next time,